Evening, everyone. My name is Ruth Ogbewekwen. I'm the focal point for research and publications at the Pan-African Lawyers Union, and was the case manager for the request for advisory opinion that has just been filed at the African Court just last Friday. So, formally, the title of the request is Obligations of States Individually and Collectively with respect to individual criminal responsibility for serious, massive, or gross violations of human and people's rights in Africa, which is quite a mouthful, which is why we have condensed that and we're calling it the advisory opinion on universal jurisdiction. And so to very quickly, without wasting too much time, to kind of understand why this request was important at this point in time, I thought it was important as well to kind of reflect on some of the historical and contemporary issues facing justice and mass atrocity prevention on the continent. And well, to start off with, as we all know, or at least are familiar with, due to some of us being directly from countries where this is ongoing, where this is happening, we have a security crisis on the continent, with ongoing conflicts in several regions in the East, in the West, in the Central Sahel, including overarching issues on the continent of terrorism, mercenarism, and all of this, of course, characterized. And so, I mean, just very quickly, based on the history as we know it, and something that I think we can all agree on is that when it comes to these issues of gross and massive violations of human and people's rights, which is very African and African Union language, the international community calls it serious violations, serious crimes of international concern. But for the purposes of the African Court, I'm just going to use. And so something that we know about history, back to the point I was trying to make before that quick clarification, is that we can all agree that we should and must never mind our business when it comes to grave and massive violations of human rights. Examples of this in the past included circumstances around World War II and the Holocaust against the Jewish people, perpetrated against the Jewish people, which, of course, the international community came together after that to say this was, in fact, a serious crime of international concern and that it must never again happen or repeat itself. But by the time the international community came around to doing that, came around to minding that business, over 6 million lives had been lost. So when we were moving forward from that, we said, okay, never again should this and must this happen again. But what happened a few years after that, particularly after the Cold War, when the world retreated back into this, including extermination against certain ethnic groups in that region. We had the Armenian genocide, and for us on the continent, we had, Rwanda, the genocide against the Tutsis in '94, soon after followed by conflict in Sierra Leone and Liberia, which was characterized by gross violations of human rights, including, most importantly, crimes against humanity. And so, again, by the time the international community and the African Union, for these respective irreversible injuries to their bodily persons, loss of property, displacements of millions of people. And so, in the aftermath of that, we then did have this era of ad hoc tribunals that sought individual criminal responsibility for these crimes. Again, recommitment to the idea of never again should we mind our business and never again should we let these crimes happen. And so in all this, one might ask, okay, fine, we can talk a lot about the international community, the setup of the ad hoc tribunals, including a lot of the customary international law that we have around this topic, that we should, endeavor to intervene. And in fact, it is a duty to intervene when these gross violations are happening. And so we might want to ask, okay, what about the African Union and the regional economic communities? And I think we can kind of distill certain themes in terms of practice at this level. So one, we can say that the African Union signed up to the international community's ethos of never again, and the ethos of the most serious crimes of international concern. The AU Constitutive Act is very clear, naming genocide, crimes against humanity, and war crimes. That also carries over to the African Charter on Human and People's Rights when it comes to serious violations, serious, gross, and massive violations of human rights, as well as the state practice of the jurisprudential practice of the African Court and the African Commission on Human and People's Rights, respectively. And so at the political level of the African Union, of course, this idea and this ethos that states should intervene and the African Union has the right to intervene has been replicated in several situations where the African Union has politically or military or through military presence intervened in several situations on the continent, including Burundi, Somalia. There was an AU-UN joint intervention mission in Darfur. But one of the things that characterizes these, interventions at the African Union Commission level is that there was no criminal prosecution, right? It was military, it was military based, it was diplomatic based, etc., etc. With the exception, of course, of this example that we have on the continent, which is the EAC, the Extraordinary African Chambers that was set up by the African Union and Senegal, what we call the Hissène Habré Tribunal, that was set up to try the former Chadian dictator for crimes against humanity committed during his regime. And so we have that one example. Recently, we have had ECOWAS, which is the Regional Economic Community, the Economic Commission for West African States, stepping in, or at least coming on board to join the Gambian endeavor for transitional justice and setting up the special mechanism for the Gambia to try Jammeh-era crimes. And that's a ECOWAS and GAM initiative. And so we also have several examples of, African Union member states individually acting under what one might call actual popularis, even if it's not universal jurisdiction particularly. And that is when they choose or they decide to, based on treaty obligations, take to a particular court, oftentimes the ICJ, regarding Myanmar. And recently, South Africa has done this, with Israel regarding the genocide in Gaza. And so I think what this really just tells us is that even if so far we've had this extent to criminal prosecution, there is at least understanding and consensus on the continent that, we're not meant to mind our business. And the goal really is to continue to maintain that ethos and to consistently intervene, or at least try to prevent, the continuous violations of serious violations of human and people's rights. And so when we fast forward now to where we are at the moment, contextually, and to contemporary times, we have obviously ongoing genocides in Uyghur, in Myanmar, in Sudan, Gaza, and several other gross violations of human rights, including in Yemen, Ukraine, Eastern DRC, Tigray, Nigeria, South Sudan, the Sahel, and so on and so forth. And so in kind of distilling, if I were to distill some of the key considerations at the moment, the key contextual considerations at the moment is that when we talk about universal jurisdiction, it's something that I would describe as consistently inconsistent. And the consistency part is that the rationale of universal jurisdiction, i.e., we should not ignore, and states have the duty and the obligations to act and to prevent, gross violations of human and people's rights or serious crimes of international concern using international community language. We're quite settled on that, right? But the inconsistency then comes in actual action, where action has been seen, and we can distill some of this, including some of the third-party state prosecutions in the aftermath of the genocide against the Tutsis in Rwanda, particularly by Belgium, France, and a few other European countries, is that even if prosecution were to happen, it happens so much after the fact. It never really happens while the situation is ongoing, right? That's not the practice that we can distill. Also inconsistent that even if we say never again and we rely on universal jurisdiction to prosecute, it's again not natural to state practice, at least not on the continent. Oftentimes, states would opt for a diplomatic intervention, a military intervention at the most, but it's not natural to go for individual criminal prosecution, even if they really should. And essentially what we then have is a gap that exists when it comes to accountability and articulation of obligations on this matter. And, at this point, PALU, Atrocities Watch Africa, we were thinking, and legal scholars we worked with, we were thinking if we left it up to states, we would continue to have this consistently inconsistent interpretation and application of this obligation, right? And so we thought that this gap exists and it's important to seek clarification on state obligation when it comes to action on serious and gross violations of human and people's rights in Africa. And so we also thought that it's not just important to make a determination on this because of the ongoing conflict situation on the continent, but also because of, obviously, as we all know, the failing multilateral architecture and structure that we find ourselves, and a move away from this coherent international intervention to a much more individualistic system where it's pretty much every state, every region for themselves, and I guess God for us all. And, that said, I do think it's important that as a continent, we really reflect on our relationship with each other and the relationship between member states and the people of the continent, and what is a member states owe to Africa's people. And I think on this, I just want to cite something that we did try to articulate in the brief, which is an essential ethos of African philosophy that cuts across a lot of the cultures and traditions of this continent. And that is something that we cite a lot, which is I am because we are, i.e. Ubuntu, and this idea of communal progression. And I think for Africans and people of African descent, really, as cultural people, how is it that we can progress, or how can I progress if my sister in Sudan has no justice, and the people who continue to violate her rights are shopping at my local mall and I see them on my streets, in my own country, right? And so, and even if the world is moving towards this individualistic justice system, the question then we should ask ourselves in reflection is that must we move in that direction, and must we mind our business, considering, what we know about the international law on this matter, state obligation on this matter, as well as our own cultural values as Africans. And so the question then that we are trying to ask the court, and we hope that we get some clarification on this matter, is, being part of this broader international community as Africans and as conscionable citizens of the earth, is it right to say that based on all that we know, there is universal jurisdiction to hold criminally responsible those who commit the most serious violations of human and people's rights? In the continent, of course, is what this advisory opinion is based off of, but we do believe that this would have broader implications on justice and accountability, internationally at the global level as well. I think I'll end there, and maybe I can leave some more reflections for a Q&A and interactive segment. Thanks.
Okay, thank you. Thank you very much, Ruth. I think you have opened our eyes to understanding where everything began from. Someone requested towards the end of your talk that you speak very slowly. I think someone is trying to get interpretation in French, but we'll ask the other colleagues who are coming after you if they could be able to speak maybe not as fast, so that we can be able to have everybody on the same footing. I'll now invite my brother, my young brother, Dr. Owiso, who will try to tell us what are the key arguments and the substance that are within the advisory request. Dr. Owiso?
Hello. Hi, Dismas. Thanks. Every time Dismas refers to me as young, I shiver a little bit, because, to be honest, I don't believe I'm quite young. But I take the compliment, Dismas, and nice to hear your voice. Thanks to Ruth for the wonderful introduction. I don't think there's much that I can say after that very comprehensive introduction by Ruth. But let me just take the next few minutes to highlight maybe the questions, the issues that we posed in the advisory, the request for advisory opinion, and perhaps just highlight some of the arguments that we have placed before the court, at least at the preliminary level. So the request poses, I believe, about 5 questions which I believe can be summarized into about 2 limbs. The first being that we are requesting the court to clarify what the legal obligations of African states individually are with respect to individual criminal accountability for serious, massive, or gross violations of human and people's rights. I'll try to speak slowly. I usually run through things, so if I'm too fast for the interpreters, please let me know. And if you'll observe that in the advisory, in the request, we are referring to these as serious, massive, or gross violations of human and people's rights, which we argue is rather a straightforward term. And you'll note that we have very carefully avoided using the term international crimes, because certainly serious, massive, and gross violations of human rights, quite a number of them, constitute international crimes. But for obvious jurisdictional reasons, and for those who followed the court quite a bit, the court is a bit hesitant to veer outside the language of human rights. So it is safer for us, for those who are wondering why, we are talking about extraterritorial application, we're talking about universal jurisdiction, yet we are not using the term international crimes, which I think probably appears maybe just once or twice in the advisory opinion. There's not much difference really, because serious, gross, and massive violations of human and people's rights, quite a number of them constitute, international crimes. So it's more or less a distinction without a difference, but that was certainly informed also by the jurisdictional scope, or other limitations of the court itself. So the first, of course, a summary of the issues or questions, the first, as I've stated, being what the legal obligations of African states individually are with respect to individual criminal accountability for such violations. And then secondly, what the legal obligations of African states collectively, that is under the auspices of the various intergovernmental organizations such as the African Union and the various regional economic communities under that umbrella, would be with respect to individual criminal accountability for such violations. And in determining what those issues, or in answering these questions, we are requesting the court, of course, to interpret primarily the obligations under Articles 1 and 58 of the African Charter, but not in isolation. We are also asking the court that when it's interpreting Articles 1 and 58 of the African Charter, it does so in light of obligations that arise from other treaties to which African states are party. And some of them, as interpretative guides in interpreting the African Charter. And some of these include, which we have cited quite prominently in the request, the Constitutive Act of the African Union, the ECOWAS Treaty, the EAC Treaty, the SADC Treaty, the COMESA Treaty, and other treaties such as the ICCPR, the Convention Against Torture, Genocide Convention, Convention on Enforced Disappearance, and two Great Lakes treaties, that is the Protocol on Prevention and Suppression of Sexual Violence Against Women and Children, and the Protocol for the Prevention and Punishment of the Crime of Genocide. We've also included there the Lome Protocol, quite a number of others, and not necessarily to ask the court to directly interpret the provisions of those other treaties, but to interpret Articles 1 and 52 of the African Charter in light of the obligations arising out of the provisions of those other treaties, which most, if not all, African states are party to. And in terms of the arguments that we are placing before the court, and we've done that in the hope that the court will actually agree and adopt our arguments, but even if the court doesn't go that way, but at least in order to inform how the court approaches the issues, or rather how the court attempts to answer the questions that we posed. And some of our position on the questions, or rather our singular position, there are several positions, but we can summarize it as this. Our position is that a purposive interpretation of Articles 1 and 58 of the African Charter, considered, of course, in light of Articles 3H and 4H of the Constitutive Act of the African Union, and considered in light of the provisions of the treaties that I mentioned earlier, lead only to the logical conclusion that African states have certain legal obligations with respect to serious, massive, or gross violations of human and people's rights. And specifically, our argument is that these obligations are the following. First is the obligation to prevent these violations, which obligation is, that is not controversial. I mean, at least going by the case law of the African Court and the entire African human rights system, the fact that African states or state parties to the African Charter have an obligation to prevent serious, massive, or gross violations of human and people's rights is not necessarily controversial. But that, going by that, one of our arguments is, our position is that a proper interpretation would lead to that obvious conclusion that there's an obligation to prevent such violations. But secondly, also, we are arguing that there is an obligation to undertake prompt, effective, and credible investigations of these violations with a view to identifying not just the victims or the pattern of violation and whatnot, but also with a view to identifying the perpetrators. That too is not necessarily controversial. In fact, our reading of the jurisprudence of the African human rights system is that this is quite, there's common ground on this so far, that there's an obligation to undertake effective, prompt, and credible investigations. But then thirdly, and which is not quite clear-cut when you look at the jurisprudence of the African human rights system, is that the obligation, and it is an argument we are making, that there is an obligation to ensure effective individual criminal accountability or responsibility for these violations. And that obligation entails, one, establishment at a domestic level of investigative, prosecutorial, and judicial processes by individual states. And what we mean by that is a proper interpretation of those provisions of the African Charter would mean then that, for instance, the Democratic Republic of the Congo has individually, as a state, a responsibility to investigate and prosecute individuals who commit serious, massive, or gross violations of human rights. And the second limb is that then also there is an obligation to establish effective regional or continental cooperation mechanisms, by necessarily saying that, for instance, the African Union as an entity has an obligation under the African Charter itself to prosecute, investigate and prosecute these violations, or that the East African Community or ECOWAS does. We are saying that these are obligations of states which they either exercise individually as a state, for instance, the Democratic Republic of the Congo does that by itself, or an obligation that they have collectively. So collectively under the auspices of the various intergovernmental organizations to which they are part. For instance, collectively under the auspices of the African Union, or collectively under the auspices of ECOWAS or EAC or SADC or any other intergovernmental formation that they are members of. So that is a bit of a distinction which is not necessarily subtle but has certain consequences. And the argument we're advancing here is then, twofold. If you look at it differently, it's twofold with respect to, one, to the territorial scope, and two, with respect to the institutional scope. With respect to the territorial scope, this is what I mean. Our argument is that the African Charter, interpreted in light of the provisions of the treaties that I mentioned earlier, imposes an obligation not only upon African states that are the locus of these violations, or where these violations occur, or those whose nationals are victims of violations, but then also imposes a similar obligation upon all other African states that are party to the African Charter. In other words, what we are saying, or arguing rather, is that these obligations are of an erga omnes partes character, which means that all African states that are parties to the African Charter owe the obligation to one another to ensure individual criminal accountability for serious, massive, or gross violations of human and people's rights, which occur anywhere on the continent, whether they occur within your individual state, within the territory of your state, or they occur outside your territory, but within the African continent. Essentially, we then want the court to declare that indeed the obligation to prosecute perpetrators of serious, massive violations of human rights is, one, it's territorial, in the sense that the state in whose territory the violations occur should investigate and prosecute. And that, again, as I mentioned earlier, it may not necessarily be a controversial argument to make, because we consider that to be quite settled in international law, and specifically in international human rights law. But then also, secondly, is of a personal and extraterritorial nature, in that a state against whose nationals the violations are committed also then has an obligation to investigate and to prosecute, regardless of where the violations are committed. And by way of example then is, if you are a national of the Central African Republic and you happen to be in Sudan and you become a victim of serious, massive, or gross violations of human rights there, your state. Despite the fact that you were not in the Central African Republic at that time, these crimes occurred in Sudan. Your country, the Central African Republic, has an obligation to ensure that these crimes are investigated and prosecuted because you are a citizen or a national of the Central African Republic. And that too is not necessarily controversial. That is, personality jurisdiction, or jurisdiction based on personality principle. And then thirdly, which is the slightly controversial one, but we, at least the arguments we are advancing in the request, we want to convince the court, or we hope that the court will agree that the third aspect in itself is also not as controversial as some would want to make it out. That is that the extraterritorial nature of these obligations, in that all state parties to the African Charter have an obligation to investigate and to prosecute such violations against African peoples, regardless of whether violations are committed and even if the victims are not their nationals. So the argument we're advancing here is that Articles 1 and 58 of the African Charter, interpreted in light of all the other obligations that we have cited, would mean that every African state that is a party to the African Charter has an obligation. It rather owes that obligation to fellow African states, which then extends to to basically an obligation to African peoples to investigate and prosecute violations committed anywhere on the continent, regardless of whether there is a direct territorial link with that state and regardless of whether there's any nationality link. As long as those violations are committed within the African continent, every African state that is a party to the African Charter has an obligation to investigate and prosecute them, because the African Charter, in terms of its regional geographical scope, applies within the continent. Universally, to the extent that we can call that universal within the African continent, because at last we checked, I believe 54 of the 55 African states are parties. So it basically covers, its territorial scope covers the continent. So regardless of whether the crimes are committed in Senegal, for instance, Kenya would have an obligation to prosecute those crimes because of their nature. And that is the argument which we are making as a third limb to it, which in effect then encompasses an obligation on African states to exercise universal jurisdiction with respect to those violations, regardless of where they occur on the continent. And unless I'm wrong, this is the first time since I started my brief presentation that I've used the term universal jurisdiction, and that is, I believe, that the short form of the short name that we have baptized the request, for obvious reasons, because that is, universal jurisdiction is one of those hot topics that everybody is still talking about. The rest of us are arguing about it. I believe even in this forum, I am certain there are quite a few of us who are not convinced that there is an obligation under international law for states to exercise universal jurisdiction. So the third limb of our argument that we're trying to get the court to come around to is that within the African Charter system, there is indeed an obligation, a universal jurisdiction obligation with regard to serious, massive, or gross violations of human rights. And I do hope, or rather we do hope, that the court will agree with us on that. So with respect to the institutional scope or the modalities of these obligations, our argument is that the obligation to ensure effective individual criminal accountability envisions modalities of discharging it as either by a state individually within its domestic systems, and of course this is indeed the primary modality for those states that are able and willing to prosecute. And then secondly, all through collective action by African states through regional and sub-regional cooperative mechanisms or efforts, as I mentioned earlier, perhaps, for example, under the auspices of the African Union, as we have seen in recent times with the Hissène Habré situation, where he was prosecuted under the auspices of the African Union in Senegal, and as we have seen, or rather as we are about to see, hopefully, under the auspices of regional economic communities such as the ECOWAS and the Gambia Court that Ruth referred to earlier. So as I get to the end of my brief presentation, in conclusion, some may ask then, why are we asking the court these questions when we think that we have the answers as regards legal obligations of states? I wouldn't say we necessarily have the answers, but we believe that we have strong arguments in this respect. But the reason why we are approaching the court with this, Ruth has given us a proper historical context of why we're going to the court. But I would just add that there's a difference between lawyers, human rights activists, and all other citizens of the African continent. There's a difference between all of us saying that states, African states, have an obligation, a legal obligation to do 1, 2, 3, or 4. That is quite different from a judicial mechanism authoritatively saying so. You and I may agree that under international law, and specifically obligations arising from the African Charter, impose an obligation on states to do as we claim they should in the request. But it's a different thing for you and I to say that. It's different when the court authoritatively says it. So only a court with legal authority can do that to the extent that we want it, to the extent that then we can walk up to states and hold them to account in that respect. So once stated authoritatively by the African court, I believe we as citizens of this continent will then have the confidence to make demands of African states, to make demands of the African Union, to make demands of regional economic communities, depending on which region you come from. And they won't then have room to argue about whether these legal obligations even exist in the first place, because that is often when you tell states that they have a legal obligation to do this, and it's something that is quite uncomfortable for them to do, their counter usually is, well, the law on that is not quite settled. And this is the importance of the African court, a court established by African states, telling us, we, the citizens of the continent and African states, telling states that, yes, you do indeed have an obligation to do this. And if you don't do this, if you don't do it, the consequences of non-compliance are 1, 2, 3. So in a nutshell, that is what we aim to achieve with this request to the court for an advisory opinion. And by just highlighting it, of course, it's available for everybody to read. We hope that, of course, we are not, sometimes when you draft some of these things, you think you actually have done a good job. But then at the end of the day, it is quite important to hear what others think of your line of thought, so that maybe you're quite sure that you're not shouting out there in a bubble. So that is perhaps why at the end of maybe this webinar, we may be asking those African citizens being, natural persons and organizations, for instance, to come on board and join hands in perhaps assisting us to elucidate some of these issues. And the African Charter framework, or the protocol framework, the court's framework provides, not in a position where we are flying in the dark and going solo, because as Ruth very ably stated, people's problem that not only affects African peoples on the continent, but anywhere in the world where they are. And it's also an issue that affects everybody else across the world. It's not only an African problem. So it is perhaps good for us to all join hands. I hope I have done some justice to the issues and highlighted them briefly. And if there is anything that needs clarification, I believe my able panelists will assist us in doing that during the Q&A. Dismas, back to you. I think I'm in trouble already for exceeding my time, but I beg your indulgence. Dismas?
Thanks, Museo Wiso. Now I have corrected myself. You are Museo Wiso.
Now you're talking.
So that we can get comparable with our board heads. No, thank you. It's certainly you have not taken a long time. It is within the ambit of what we have assigned. And thanks for the clarity that you have given us. I am sure that there are going to be questions and comments about both what you have presented and what Ruth presented, and what my other Musei, Professor Chidi, is going to be speaking to us, and he will be able to address the legal implications of this request. And in particular, he will have to look at the significance of a favorable determination. What does a favorable determination look like, Musei Chidi, and are we likely to get it? Over to you, Professor Chidi.
Well, thank you, Dismas, and good day, colleagues, wherever you may be. Now that you have introduced the gem that's Ruth and the young person, I presume you are visiting the old people's home to find out what the old people think about this entire thing. Um, Now, I should also, and particularly the Don Dare, who leads the Palu team for this and taking the leadership on it, but also for the work that is done consistently to help us articulate and invent, to the extent that these norms permit, a framework for in law for addressing the challenges that we face as the peoples of the African continent. Because I'm standing between folks and the questions, I see there are already hands up. I want to try and telegraph this fairly quickly. A bit of just to append one or two things to the context that Ruth provided before going to the question of legal implications, if any. This is April. It's the month of the genocide against the Tutsi of Rwanda, which began on the 7th of April, 1994. And I note that Marie-Louise Barichako is here, who used to live in the Gambia, and worked at the Secretariat of the African Commission at the time. At that time, in 1994, the continent was casting about for a framework of response to the genocide that was denied by the rest of the world, as it happened real time, slow motion. And nobody had a basis. Nobody could imagine their way through it. And so what happened? In the aftermath of that, we all got into, clearly there was a great deal of mea culpa, institutional, personal. And the question was what to do. And we all got into a massive hand-wringing process about Article 58 of the African Charter on Human and People's Rights. That was the first time people started getting used to the idea that there was Article 58 to the African Charter dealing with serious and massive violations of human rights and how to handle them. But the tools in Article 58 on the face of the text, or the legal imagination at the time, appeared inadequate to locate a response within Article 58. And ultimately, the only thing that two things came out of that entire mea culpa festival. One was the creation of special procedures within the framework of the African Commission, starting with the Special Rapporteur on summary, arbitrary, and extrajudicial executions, which is a long distance when you think about it from genocide. I mean, in terms of scale, it wasn't, it was an inadequate response. The second, of course, was the IPEP, the International Panel of Eminent Persons, the Organization of African Unity level, which did not report until 6 years later. And I think that demonstrated and dramatized the need for something more significant. Now, secondly, 20 years ago, pretty much, again this month, my brother Pascal Kambale from the DRC and I traveled to Dakar, Senegal, to meet ultimately with the president of Senegal at the time, Abdoulaye Wade, and ultimately at the technical level with his minister counselor, about whom I will not give any details in an open forum here, to begin the negotiations that ultimately foregrounded and made possible the trial of Hissène Habré. And the first thing we confronted was what was the legal basis for doing so. As we met at Savannah Hotel on the Corniche, what was the legal basis and how could Senegal be And the reality was we were navigating a political and diplomatic minefield. But there was also an optical minefield. At that time, the contretemps between the African Union and the ICC was beginning to unfold, and we believed that Africa needed to take responsibility, and the AU needed to take responsibility for what was effectively at the time beginning to look in terms of its optics like a weaponization of universal jurisdiction. That negotiation wound its way through quite a while, and it was nearly 1 decade later that the proceedings in the Hissène Habré case eventually concluded successfully. But ultimately, it took the political will of the AU countries, pressure from the weaponization of, at least that's how it was framed, pressure from the weaponization of universal jurisdiction, mostly overseas, outside the African continent, and a little bit of invention in Senegalese law for us to be able to make that trial possible. And I think the lesson was that, and as we went forth with whether it's Charles Taylor in Sierra Leone or the frustrations of the Habré Tribunal now in South Sudan, that if the continent of Africa does not take responsibility for accounting for atrocities against Africans, no other persons will take it as seriously. The question is, how can we bring that about? The major contribution of this, the current proceedings, is to pose the obligation, or two things in terms of its contributions. One is to pose the obligation of universal jurisdiction in Africa as grounded in human rights law. And that means, secondly, human rights law in the African Charter, to say that it's implicit in a joint reading of Articles 1 and 58 of the African Charter. The second is that because we say that it is founded in international human rights law made by African countries, secondly, therefore, it is an obligation erga omnes. And those are new propositions in the way, if and when they are framed in that way. There are challenging propositions too, I suspect, as this goes forward. And no one should take it for granted what the outcome of the contest that ensues will be. What is likely to happen? And because they are erga omnes, it also means, therefore, that as the most articulate farmer on the African continent, Dr. Wiso, has said, it means that therefore, these obligations are extraterritorial, at least among African countries, or within the territories of Africa. Now, the good thing about the advisory procedure as the mechanism for bringing this is that the advisory jurisdiction of the African Court is effectively a convening of all member states of the African Union. Under Rules 82 and 83 of the Rules of Procedure of the Court, when an advisory case is initiated, or a case is initiated under the advisory jurisdiction of the African Court, first of all, it is circulated to the judges of the court. But secondly, and more importantly, it is circulated to every member state of the African Union, irrespective of whether or not they are party to the African Court Protocol. Every member state of the African Union, and now, as Dr. Wiso said, there are 55 of them, 54 of whom are party to the African Charter, which is really the foundational text for the present proceeding. The only state that is not party to the African Charter in the AU is Morocco. And so every one of those 55 states is entitled to participate in the proceedings. And after this, what happens? After circulating these, the commission has got to fulfill the requirements of the court has got to fulfill the requirements of admissibility. By the way, the African Union institutionally and its main organs are also invited to participate by themselves. Now, the court has to undertake processes of admissibility. And so it has to verify the standing of PALU to initiate the proceedings. That's the first thing. I think that's fairly easy, and there's precedent in the court for that. Then it has to verify from the African Commission that this does not involve a matter presently pending before the Commission, and in fact also has to do that with the registry of the African Court. Those should not be too difficult. And thereafter, the states will be invited to file their observations. It could be a process entirely epistolary in writing. It could also involve hearings, the application of the parties involved, or particularly the applicants, or in fact by the court acting of its own motion. We don't have any indications yet, and we have not yet made up any minds on that at this particular point. But thereafter, we're then going to go into the processes, and this is also an invitation to those who are interested to engage with this in the capacity of amici curiae. I may wish to consider that to probably get in touch with Ruth or Dunn at the Pan-African Lawyers Union, and let's try and discuss that and at least make sure that any such applications can be done in time, but so that scheduling ahead of scheduling considerations. Advisory opinions have been known to be issued as quickly. I think the Pan-African Parliament advisory opinion took less than 6 months to conclude. Others have also taken a little longer. But I think that actually took less than 2 months to conclude. And so for those who are interested in participating in these proceedings as amici, it may be necessary and useful to get that in early enough, quickly enough, so that we do not take too much time on that. And let me just round off with one final word so that we can open this up for participation. And it's the fact I keep going back to about the continent. I'm not an apostle of African solutions to African problems, because international crimes are not African problems. They are universal problems they are problems of international peace and security. Let's be clear. Africa is not a ghetto for international crimes. So I always ask the question: if you say African solutions to African problems, you've got to have clarity about what is an African problem. There is a difference between an African problem and a problem in Africa. Sudan is a problem in Africa. It is not an African problem. If you've got Turkish Bayraktar drones dropping, doing stuff, and Reaper drones from other parts of the world doing stuff, and you've got UAE rustling stuff, you've got Saudi Arabia doing its own thing. I disagree with Judge Aiti. Let me be very clear on the issue of African solutions to African problems. But I do think that African agency and African autonomy is very important to promote, and African responsibility for the things that happen on our continent, and the abdications that continue to happen, particularly at the sovereign and intergovernmental level, can be reined in and reasonably governed with a clearer articulation of legal standards and obligations. That is what we set out to contribute to through this advisory opinion. And my hope is that there'll be stakeholding, and I hope, as a matter of fact, as a legal team, is that there'll be stakeholding and calibration beyond those of us who are currently involved. And as many people as are willing to take a stake in this, you please do so, so that we no longer have to export to the rest of the world responsibility for ensuring accountability for the atrocities that happen on our continent. Nor do we have to wrestle as we did 32 years ago in the inadequate manner that we did with the challenge of inventing ultimately inadequate responses to the genocide that was called preventable. Can I yield? Thank you very much, colleagues.
Thank you very much, Professor Chidi. That is very useful in terms of wrapping up the sessions for the our presenters, and I can see quite a lot of questions and answers back and forth, and we'll get to it immediately. If you want to, if there's anyone who wants to speak, please put up your hand. There's a way in which you can put up your hand in the chat, and then we'll be able to ask you to speak. I don't know whether, Ruth, that is acceptable. We can be able to unmute such a person who wants to speak. We'll
Yes, that's
see the
fine.
logistics of that. Okay, all right. But let me first get to a couple of questions that have been asked and a few comments. There is a particular question that is for you, Dr. Owiso. The question is, how independent is the African Court of Justice itself, and what concrete efforts have been made so far beyond drafting the request to secure political buy-in from African Union member states, many of whom have historically resisted universal jurisdiction as a neocolonial tool, or nations like Ethiopia that has proven record of committing ethnic cleansing? That is for you, Dr. Owiso. I think there's another one. This one can go to either Ruth or, yeah, I think so. Does the request for advisory opinion cover accountability of corporations, or is it restricted to individual accountability? Right? We saw people saying you did a very good, commendable work on the presentation. Okay. Then Mzee Chidi, you have greetings from Maliru Wiz Barichako saying, how are you? And it's good to be able to hear brothers and sisters on what you are doing. Okay. Then there's another question, which I think possibly this one arises from what Mzee Chidi, Professor Chidi is presenting. How do I join the Pan-African Lawyers Union? Formally, thank you, but possibly it's not joining the institution, but joining the process that we are engaged in the advisory opinion. There is a quick question from Tigray Advocacy UK. How do you respond to anticipated resistance from states arguing that Articles 1 and 58 do not implicitly mandate universal jurisdiction, but rather territorial or treaty-based jurisdiction? Why not focus on their international obligations they signed internationally via the UN mechanism? I do agree with Odin Kalu's proposal of admissibility to 55 countries, but the delay so far not acceptable in part of Palu. Thank you, Odin Kalu, for making it crystal clear. African problems, African solution is a dead political mantra from African dictators. Okay, can we begin with the Dr. Owiso response? Then we'll go to Ruth, and then Mzee Chidi to get to where they're asking him questions from the Advocacy Tigray UK. Owiso?
Yes, thanks, Don. And for the question, how independent is the African Court on Human and People's Rights? My opinion is that the court has so far proven itself to be fairly independent. And I say that because its jurisprudence speaks for itself. And I'm not particularly privy to any interference, direct or otherwise, that the court faces or that the court has succumbed to. But from, when we, and I have to confess, I'm primarily a farmer and then a lawyer. And as a lawyer, we often judge judicial institutions by their jurisprudence, because often there's not much that courts can do. There's something they can do, but most of their work, they speak through their jurisprudence. And looking at the jurisprudence of the African Court in its very short history, to me, it's fairly indicative of a court that is quite independent in terms of its mandate. So in that respect, I would not worry about the court's independence. But of course, we have to acknowledge that the nature of this request for advisory opinion is a bit of a hot political potato, so to speak. The legal questions that we are raising there and the legal issues that we've raised there certainly questions that African states have engaged with for quite a while. And obviously, they've been a bit resistant to accountability for some of these violations. So obviously, we do not expect that African states are going to be falling all over themselves to come and join us and say, yes, these obligations do indeed exist. But that, to me, will not necessarily have an impact on the independence of the court. Yes, so far we just filed the request on Friday. I believe that's when PALU filed the request. So not much traction has been, we haven't seen much traction since Friday. But there's a lot of work that all the partners, PALU at Trustees Watch, and all the legal, and the entire legal team involved have been doing even before filing. And we've so far received lots of interest from not just from civil society organizations. Quite a number of them have indicated that they would want to join in this effort and probably seek the court's leave to be amici individuals, African individuals, and even beyond the continent. And also, so far, we have commitment from at least one African state to also join in and at least have their voice heard. We are not, of course, certain what they're going to say, whether they're going to support the request or not, but it's indicative of the kind of interest that we so far have. I mean, 3 or 4 odd days after filing. So I believe that going forward in the next maybe month, we will hopefully see much more interest in it. But I can confidently say that so far there's been quite some interest, and we are hoping that interest will increase as we go along. And particularly because this is an issue that is of importance to pretty much all of us as African citizens and actually global citizens, because as Professor Chidi said, violations of human rights, especially of a serious and massive and gross nature, are not unique to the continent of Africa. They are global problems. So we hopefully will see more interest therein. But then maybe just a little bit on the last question as to whether states will resist our interpretation of Articles 1 and 58 with regard to universal jurisdiction. Well, that will not be surprising, because quite a few African states have been a bit resistant to the idea of universal jurisdiction. I always argue not because they hate accountability, but because of the historical underpinnings of the concept of universal jurisdiction. Historical underpinnings in this sense, I mean the bastardization of the concept in its earlier years, when it was used, when it had a bit of colonial connotation. So that I don't quite agree with what quite a number of fellows say about universal jurisdiction being inherently colonial. I don't believe it is. What the problem I think we had with universal jurisdiction in its earlier days was the way in which it was deployed in a very colonial sense. But the idea of universal jurisdiction, to me, the basis of it is accountability for serious crimes, so basically international crimes. And no one disagrees, I believe, with the need for accountability for this. So part of the reason why we are going to the African Court to hold its own member states accountable is to tell them, hey, this is a concept. There's no way you're going to come to your court, a court that you established by yourselves, the African Court, and tell the African Court that the African Court is being neo-colonial by interpreting the treaty to which you are all party, a treaty that you came up with. So that is actually part of the importance of going to the African Court with this, because the African Court, we believe, has legitimacy to both legal legitimacy and socio-legal legitimacy to actually tell African states, yes, you created us as a court and you signed on to this treaty. In fact, you drafted it and you signed on to it. We are simply interpreting it for you. We are not importing any alien or foreign concepts. These are concepts you yourself came up with and signed on to, and we're simply interpreting them for you. And then also, of course, we have not elided any obligations in other treaties. That's why at the beginning of my presentation, I said the primary instrument we are relying upon is the African Charter, but we are asking the court to interpret the African Charter in light of the obligations that these states also have under other treaties, be they treaties concluded under the auspices of the United Nations or any other multilateral treaty. So we are asking the court to interpret the African Charter in light of the state's other obligations under those other treaties. I hope. Back to you, Dismas.
Thank you, Dr. Wiso. Ruth, there was a question specifically for you.
Yes, thanks, Dismas. And particularly on corporate accountability, the answer is no. And I have just very quickly put the title of the advisory opinion. And this is in addition to Dr. Wiso's presentation on the particularities of the requests and the arguments that we put forward, and particularly zoning in on state obligations, generally state obligations to prevent and intervene, but specifically state obligations to prosecute, whether individually as states or collectively as states, to prosecute and to seek individual criminal accountability for massive or gross violations of human and people's rights. So the short answer for now is that no, the advisory opinion request does not go into corporate accountability, but rather it goes particularly into individual criminal responsibility and prosecution. Of course, that's particularly tied to individual criminal responsibility and the several modalities of that, including joint criminal enterprises, aiding, abetting, etc., etc. Now, with that said, I do believe that the angle of corporate accountability is a very important angle when it comes to, a serious and gross violations of human rights in Africa, particularly when we talk about extractive industries. If you look at what's going on, for instance, in DRC, or maybe even particularly Eastern DRC, a lot of the mass atrocities there and a lot of the, language that we're using is a gross and serious violation of human and people's rights. It's directly tied to the extraction of minerals, right? And that's a very important angle. And I think whilst the request in and of itself cannot go into all the details, I think these days we actually have a page limit with the court, which is 60 pages. So we can't get into everything, make our substantive argument and get into every single angle of a particular issue that we're seeking clarification on. And I think that with that said, and considering that corporate accountability and corporate responsibility towards these serious violations of human and people's rights on the continent is a very important issue and a very important angle. That's a very ripe opportunity for amicus or state intervention submissions. And so we would hope then that what we cannot, or what the applicants, PALU in this case, could not engage in because of page limits or wanting to particularly focus on one issue, not to distract the court or to muddy the waters in this case. What we couldn't do, we would hope and we would invite, I think Professor Chidi also mentioned this a bit, applications for amicus to really get into some of these specific and niche areas of a particular issue, as well as state interventions. You heard Dr. Wiso, we received communication that one state will submit state intervention, but we don't know what they're going to say, right? But if anyone here is wanting to speak to their government, speak to their state in that position, this is also a potential issue to submit on, which is on corporate accountability or corporate responsibility, and the extent to which these obligations exist in that aspect. So so the answer generally is that no, that's not what the request is about, but it's a potential avenue to make that linkage during amicus or state intervention. Thanks.
Thanks, Ruth. Muzechid, I think there are a couple of things that were asked about you. One of them being, what would be the best way on which people can join this kind of momentum of the advisory and it's the request that we are making. And then I think there was also another question. Just 1 second.
I've seen that.
Okay, you have seen. Okay. Yes, sir.
So let me just take up from where Ruth started or stopped. So in terms of how folks can join, I think Ruth has reinforced that, and I also did kind of mention that you can simply make contact with the Palu team, or you can email legal@lawyers-of-africa.org, and we can establish contact on that basis and help shepherd if that's needed. That's the fairly straightforward way to start that. I think I want to say something about the question about resistance by African states. We shouldn't make the assumption that Africa is a country. It's the one thing that Colony did effectively, to portray Africa as one country, to which white people who bring their making skills and just or the other knives and start carving up things. You have jurisdiction amongst African countries are quite profound on a lot of these issues, and quite often reflect the positions and experiences. And this is one area in which African states are not averse to either having or in fact articulating their interests quite forcefully. And I do not expect anything less in the present proceedings. I do expect that there will be disagreements between African states. Some will agree, others will disagree. But one thing is quite certain, which is our current situation is no longer acceptable. I think Dr. Wiso has made the situation as clear as could possibly be. So will there be states that disagree with an assertion of universal jurisdiction as a human rights obligation? I do expect that there will be. And I would not class that as resistance. I'll simply say those states will be making a legal argument and then well within their rights to do so. Will there be states that also do agree that there is in fact such an obligation? I do expect that there will be African states that will do so. And the great thing that this case does is it potentially removes universal jurisdiction in Africa from the purview of colonial weaponization and makes it clear that African states are capable, on the basis of equality in international law, of equality of sovereign agency in international law, of participating with a clear eye on ensuring legitimate accountability for atrocities in the continent or anywhere in the continent. That will take away the justification for any Messiah initiatives on the question from outside the continent on the question of accountability for these atrocities. Now, there's a question about, and I think a related issue is the issue of to the independence of the African court is the question of legitimacy that African institutions can bring to these issues which internationals cannot. For those whose memories go that way back, Algeria faced down every attempt at international accountability for the atrocities in its response to the annulment of the Algerian Civil War, which followed the annulment of Algeria's elections in 1991, won by the FIS, the Brotherhood, in effect, right? Now, Algeria absolutely dismissed every act of response or attempt at accountability or condemnation from the rest of the world as colonial. There was only one response it could not dismiss as such. In 1995 in Lomé, for those, as I said, whose memories go that way back, at the, I believe, 13th Ordinary Session of the African Commission on Human and People's Rights in Lomé, the Commission adopted a resolution condemning the violations in the Algerian Civil War. What followed was an Algerian blitzkrieg, diplomatic blitzkrieg. It sent a presidential representative to every member state of the African Union who had a national sitting on the African Commission, to press the Commission to reconsider the resolution. Algeria sponsored one of its finest diplomats and jurists to become a member of the African Commission so that there will be no future opportunity for the African Commission to condemn its behavior ever again. It did not bother with any other part of the world condemning it. So African countries are very sensitive to the idea that the possibility of being condemned by African institutions or being challenged by the African institutions, because that cannot be called colonial or neo-colonial. And the final thing I want to deal with is the question by my big sister, Professor Eki Omorogbe, which is what the scope of remedies that can be ordered or evinced if this is successful, to which the answer will be, what would success look like? First of all, we've got to cross the admissibility thresholds. I think that should be relatively easy, but that will still be part of success. As to what dispositions the court could order, that will have to be dealt with when we get to that stage. Could the court order enforcement action? I suspect not, partly because that is dealt with under a different set of standards. Article 19 of the Peace and Security Protocol of the African Union requires or empowers the African Commission on Human and People's Rights to report to the Peace and Security Council of the African Union on questions within the scope of the Peace and Security Council, such as questions that engage with regional peace and security, and that extends, of course, to cases of mass atrocities in any territory of the African Union member states. I do not think that the African Court could possibly regard the Peace and Security Protocol or the Protocol for the Establishment of the Peace and Security Council of the African Union, to call it by its proper name, as a human rights instrument within the jurisdiction of the African Court. Although we are calling in aid the provisions of Article 19 in making the argumentation in this case, it's not by way of inviting the court to treat Article 19, the Peace and Security Council Protocol, as a human rights instrument. So my sense is that in terms of measures of enforcement, that would fall within the framework of the Peace and Security Council. But in terms of legal and institutional measures, measures of legal accountability, to put it better, I guess, that is what we are looking at. So that's measures of legal accountability, institutional as well as prosecutorial. But above all, also the question particularly of obligations of cooperation between and amongst African states on this matter. We do expect some dispositions to come out on those. Thank you.
Okay, thank you very much, Professor Chidi. Yes, and I can see that there are more comments coming in through. Yes, Ekiemise Omorobe, very exciting initiative. My mind is buzzing. It is criminal accountability, the establishment of courts, such as for Hissène Habré, for reasons of costs, etc., etc. I think some of these are comments that are coming in from people. Good evening. I note that Ruth actually talked about addressing ongoing gross violations and not necessarily allowing them to end first before instituting accountability mechanisms. However, when addressing such ongoing conflicts through individual criminal responsibility, how would we address the issue of immunity for individuals in high offices where the perpetrators hold such offices? Thank you for the wonderful briefing. So what is coming in, Ruth, is the question of immunities of individuals with high offices. It's an area that we didn't be able to address. Then there are also another question that has come in following our previous suggestion from the Africa People's Parliament, prompted from the Algerian experience? Is it early to take seriously our suggestions to overcome the barriers imposed by dictatorial, just one second. Yes, by dictatorial leaders. I think this one goes to Chidi because of the suggestion about the Algerian experience. So Ruth, first, there's something for you, and then we'll go to Chidi as we try to wrap up.
Thanks, Dismas. And before I actually answer the question, I think the comment immediately preceding that was from Bettina, who heads, I think, Wayamu Foundation. And just very interesting to say, full circle, Bettina gave me my very first job in international criminal justice when I was a student in Kenya. So I'm happy to see you, Bettina, and thank you very much for joining. To answer the question, I think that it's very just in terms of reflecting on how justice systems go, and also talking about my presentation initially, particularly on individual criminal responsibility whilst the events or whilst the atrocities are still ongoing. I think the first thing that we can acknowledge is that the trajectory of international criminal justice, or the trajectory of accountability general, in terms of the lessons learned from the earliest forms of mechanization around this topic, that's Nuremberg, to the ad hoc tribunals, to the hybrid tribunals, and even our national court systems, is that you kind of have to start small, right? And then grow big. There's this thing called the big fish, small fish thing, where you start small and then you go bigger and bigger and bigger. And this is the trajectory, this is the distilled experience that we've seen when we talk about individual criminal responsibility for gross and massive violations of human rights, but as the international community calls it, most serious crimes of international concern. Now, that's one. And so in starting small, and then going big. I think the first thing then, and this is particularly relevant to this advisory opinion request, is that starting small would mean, first of all, establishing, articulating that there is an obligation to prosecute on the universal jurisdiction, and prosecute particularly individual criminal responsibility. Now, the modalities of who gets prosecuted, when they get prosecuted, that's something that could potentially come as a second layer, but it's extremely important at this very stage. And this is why we've brought this request forward, to have this articulation by a court, not by a political body, not by an international body, but particularly by an African court, speaking on the obligations of the African member states to prosecute. And so, yes, we have a theory, Palu, the legal experts that we've worked with, some member states, think that this is possible and this is written into the law, and this is an obligation based on existing international human rights law. But that articulation is very important to have as a first level. The second level would then be who can be prosecuted, who cannot be prosecuted, etc., etc., etc. That's one. Two, is starting big and small also means recognizing the realities of the world in which we live in. And the realities of the world in which we live in is that no one is prosecuting heads of state and presidents whilst they are in office, or the most serious senior generals. This has not happened, right? We have arrest warrants issued, even by international criminal courts, the ICC, etc. We have arrest warrants issued against sitting heads of state, Bashir, even Netanyahu at the moment. But the reality of the matter is that it's an extreme hardship to arrest these people and actually prosecute them. So while we have this, general idea of immunity, depending on which side of this argument one might fall, but there is this argument that's being pushed and proponed that, sitting heads of state should have immunity for prosecution. Personally, I do not agree, but that's a conversation that's happening. But at the same time, the reality is that sitting heads of state cannot be prosecuted. It's impossible to have that to execute that in the current global world order that we live in. So now we recognize that difficulty and the limitations of actually effecting prosecution against someone who is at the most senior position, committing or perpetrating these crimes. And so the way and the innovation around international justice or just criminal justice in this way is to start for something called, we call at PALU, the lower hanging fruits, but then also what international criminal investigators and prosecutors have called the smaller fishes, right? So you start for the people who do not have immunity, right? The foot soldiers, and then slowly work your way upwards. No one is going to be in office forever, right? Immunity doesn't extend, at least in the ways that I've seen it articulated, doesn't extend to people who have, left office. Of course, we see Hissène Habré as a prime example of that. When he was in office, he may have had immunity, but when he left office, the African Union and Senegal established the Extraordinary African Chambers. And it's the same thing that's happening with the Gambia and ECOWAS at the moment when it comes to Yahya Jammeh. So no one's going to be in office forever. And so what we're saying is that if you at the very least have this obligation to prosecute, and that's established, state parties to the African Union system can begin to build that case, can begin some kind of system of accountability, some kind of system of individual criminal responsibility as we wait for the day when this person is no longer in office. And by that time, the advantages of starting this process of criminal accountability would be that you would have sufficient evidence and sufficient pathways towards a coherent and properly grounded case against this big fish that you waited so many years to get. I think I'll leave it there. Thanks.
Thank you, Ruth. Muzey, there was a question about the experience of Algeria.
I didn't quite understand the question. If you can recap it again, that would be useful, please.
Okay.
I've tried to look for it. Now, following our previous suggestion to the African People's Parliament and prompted from the Algerian exterior, is it too early to take seriously our suggestion to overcome the barriers imposed by dictatorial leaders? And because I don't have the context of the earlier suggestion, it's a little difficult for me to answer that sensibly. So if the author could help with further explication, I could try. But I should just say this by way of supplement, that the advisory opinion is on universal jurisdiction. That's the threshold question of universal jurisdiction, not on defenses that could be exercised if or when a mechanism of culpability or accountability is triggered, which will be what could arise when you talk about immunities. It's also the case, however, I think Ruth has made most of the points here, there is actually genuine divergence of opinion, well-founded in jurisprudence and norms, credible norms, on the question of immunity of heads of state, in particular, of sovereigns. The arrest warrant case by the International Court of Justice makes it quite, confuses things quite substantially. As a matter of fact, the provisions of the ICC statute on the question of immunities are not as straightforward as my friends, whom I like to call ICC fundamentalists, like to put them forward. And this obviously is not a conversation about either ICC fundamentalism or about immunities in international law, immunities particularly of sovereigns only. I'm not talking of senior army officers, that's very clear, or senior military officers, that's straightforward. I'm talking about sovereigns, heads of state, heads of government, and foreign ministers. That is not at all anywhere close to being as clear, remotely to being as clear as ICC fundamentalists tend to suggest. they all get their legal genitals in a twist when very excited. And I'm using my words here very deliberately when it concerns African leaders. When it concerns leaders from other parts of the world, their legal genitals are not as excited. And that for me is challenging at various levels. But I'm hoping that we can convene another conversation on the question of immunities and go toe to toe on that. But for the moment, we are dealing with universal jurisdiction and the responsibility of African countries to ensure that there is accountability for atrocities that happen on the African continent. And I think we want to focus on that. Thank you.
Okay, thanks so much, Chidi. I think that we have come to 1 hour and a half, which I think people have been patient enough. I think the conversation has been quite engaging to the level that we don't know that people didn't know that we had gotten to 1 hour and a half. I don't know whether each one of you, Chidi, Ruth, and Dr. Wiso, each one of you has a 1 minute final word before I close the webinar and allow people to continue the other things they are pursuing. Any?
Yes, perhaps just to thank everybody for attending and to close with, I like borrowing Chidi's words every time I have to address anyone. And I say that we, as Chidi always says, we as African citizens or peoples, we need to have sort of the confidence to make mistakes, learn from them, pick ourselves up, dust ourselves up, and move on. And I believe that this initiative by Palu and partners is one such opportunity for us to actually engage the systems and mechanisms that we have put in place as a continent, specifically the African Court, and actually put it to task to do something about a particular issue of concern to all of us as African citizens and to the rest of the world. The court has a singular opportunity here to clarify legal questions of importance and to provide guidance not only to us as citizens of the continent, but also to African states, and to give us a platform on which we can start then making certain specific legal demands to African states, or rather making demands from African states. And again, just to finish with this, I'll repeat what we said in the beginning. This is an open conversation, and we would actually encourage everyone. The court is quite liberal, going by recent events, quite liberal in its approach to welcoming amici and all that. So anybody who is interested, be it as an individual capacity or as an institutional capacity, or even states, because I believe I've seen 1 or 2 sneaky state representatives in the audience. Even states are very welcome. So that we join hands. I'm not saying that you come on board and agree with us. No, that is not necessary. It would be nice to agree with us on this, but that's not necessarily the point. We want all hands on deck. We want all opinions on the table, so that the court is able to appreciate the issue. So that we are very open to that. In fact, we encourage it. We will be having more conversations to try and build that sort of coalition. So thank you.
Thank you, Mzee Dr. Wiso. Ruth, Chidi has said that he fully falls behind Owiso's final words. So Ruth, any word?
No, just to say, on that point of amicus, if anyone needs, if anyone wants to reach out, I have put legal at Lawyers of Africa in the chat. So yeah, please do reach out to us, and we'd be happy to, begin the conversation to facilitate that if necessary. Thanks.
Thank you, Ruth. Thanks, everybody. It's been very nice hosting all of you, and on behalf of Pan-African Lawyers Union, ourselves at Trustees Watch, our very able lawyers, international lawyers that have been helping us, we do thank you for having taken time to join us, and we do hope that in the near future we should get back to you should there be any progress, or even if there is no progress, about the advisory opinion, so that we can still be able to have a conversation and update you on where we are. So on behalf of the organizers, Thank you for joining us, and I wish you a very good morning, very good evening, wherever you are. Thank you.